like the water under the bridge, sweetheart. But the roses pale, the moon turned white, and the water froze neath the bridge one night.
Mom, are we not going back to Dad?
No, hon. We'll stay here for good. I know this is not what you wanted, but just know that I love you and your daddy loves you very much too. But things will never be the same.
This court will now come to order.
For item number 1, federal proceeding number 03472-25. Appearances, please.
Attorney Beverly Rodriguez appearing for the petitioner, Your Honor.
Prosecutor Henry Cristobal appearing on behalf of the Solicitor General, Your Honor.
What is your pleasure, counsel?
We pray for the recognition of the foreign divorce decree, Your Honor.
Your Honor, may I manifest?
Proceed.
Your Honor, the state has the duty to protect families. With that, it is imperative, Your Honor, that an investigation be conducted, that no collusion is made between parties.
Okay, granted. Counsels, I have noticed that in your pre-trial order that there is no Yugoslavian law presented and marked. Any reasons?
Permission to speak, Your Honor.
No need to ask permission, counsel. I already asked you.
I'm sorry, Your Honor. I'm just practicing law for a year, Your Honor, and I am not aware that I have to present the Yugoslavia law before your court, as I believe that the Yugoslavia and the Philippines are both members of the United Nations, so it is not required to submit or present.
I beg to differ, Your Honor. Settled is the rule that the court do not take judicial notice.
Your Honor, in fact, we had a similar case just last month where the other court did not require us to present the foreign law.
Excuse me, counsel, but can your experience be used as a precedent in deciding this case? Hell no.
But Your Honor,
Mind your words. Order!
Your Honor, please help me. I've been living through hell every time I'm with him. Please release me from this burden.
Let me take a moment to clarify the doctrine of judicial notice. Under Rule 129, Sections 1 and Section 2 of the Rules of Court. Under Section 1, the court is mandated to take judicial notice without the need of evidence of the following matters. Number 1, the existence and the territorial extent of states, their political history, forms of governments, and symbols of nationality. The second one, the Constitution and the laws of the Philippines, including the official acts of its legislative, executive, and judicial departments. The third one is the law of the nations, which includes the customary international law, treaties, and generally accepted principles of international law. The fourth and the last one is the official acts of the government, departments, and officers, as well as the administrative agencies in the Philippines. These are the matters of such fundamental importance that they do not require formal proof. The court is bound to acknowledge them as established facts. Now, under Section 2, the court may take discretionary judicial notice of the matters that are of public knowledge. Those are so notorious and generally known that they cannot reasonably be disputed. Second, facts capable of unquestionable demonstration, meaning facts that can be verified with certainty, such as scientific principles or natural laws. The third one is the facts that are already part of the court's official records, eliminating the need for further proof. In exercising discretion under Section 2, the court must be cautious, ensuring that the facts are truly beyond reasonable dispute. Judicial notice serves to expedite proceedings by eliminating the need for the proof of universally accepted facts, allowing the court to focus on genuinely contested issues. I hope you understand that. Stenos ordered. In today's in-court hearing, Prosecutor Cristobal appeared for the state and Attorney Rodriguez appeared for the petitioner. The petitioner and her child are also present. Today's incident is for the last day of the presentation of petitioner's evidence. However, the petitioner failed to present and offer during the pre-trial the law relating to the divorce of Yugoslavia. Considering that there is no foreign law established, this court will apply the doctrine of processual presumption, and as such, the Yugoslavian law will be presumed to be the same with the Philippine law. But it is well settled that there is no law recognizing divorce here in the Philippines. Due to this court finds it necessary to dismiss this case without prejudice, to refile it. So ordered. Next case.
Miss Gravenikov, the food here is quite good, right? So, no gums. Let's talk about your case.
Attorney, this was the judgment of the court in our previous petition for the recognition of the foreign divorce.
Miss Gravenikov, I see here that the decision of the court is without prejudice, which means we may petition again the court for the recognition of your divorce, foreign divorce. And this time, the Yugoslavian law on divorce will present and offer it as evidence. Actually, Section 3 on the rules on evidence states that during the trial, the court, on its own initiative or on the request of a party, may announce its intention to take judicial notice of any matter and allow the parties to be heard thereon. After the trial and before the judgment or on appeal, the proper court, on its own initiative or on a request of any party, may take judicial notice also of any matters and allow the parties to be heard thereon if such matter is decisive of a material issue in the case. Right? So, that should have been done. So, let's do this.
Thank you, Attorney.
In Philippine legal system, judicial admissions play a crucial role in our court proceedings. But what exactly are judicial admissions, and how can they affect a case? Rule 129, Section 4, Judicial Admissions. An admission, verbal or written, made by a party in the course of the proceedings in the same case does not require proof. The admission may be contradicted only by showing that it was made through a palpable mistake or that no such admission was made.
Ms. De La Cruz, do you admit that you were present at the scene of the incident on June 10?
No, attorney, I don't remember.
Ms. De La Cruz, do you admit that you were present at the scene of the incident on June 10?
Yes, attorney.
Can you repeat that again?
Yes, attorney.
Let the records show that the defendant has admitted to being present at the scene.
By making an admission, De La Cruz eliminates the need for the opposing party to prove his presence at the scene.
Your Honor, may I present the evidence marked as Exhibit A, the conversation between the plaintiff and the accused to prove the authorship of the text messages?
Granted.
Mr. Benny, do you recognize these text messages?
No, attorney.
Your name is shown as the sender of these text messages. Do you admit sending these text messages to the plaintiff?
No, attorney. They have been cropped and manipulated. This is not a complete conversation.
Are you suggesting that this evidence presented here is fabricated?
Yes, that's exactly what I'm saying. These texts have been altered. They don't show the entire context of our conversation. I don't have the complete messages with me right now, but the ones presented here leave out key parts of our dialogue.
So are you claiming that the messages presented are out of context and do not represent your admission in relation to this accusation?
Yes, that's correct.
Judicial admissions help streamline court proceedings by avoiding unnecessary evidence presentation, making the judicial process more efficient. Judicial admissions are a powerful tool in the judicial process as they serve as conclusive evidence of the facts they assert. Unlike other forms of evidence, which may be subject to dispute and require validation through testimony or documentation, judicial admissions are unequivocal acknowledgments that bypass the need for further proof. This feature significantly reduces the time and resources expended on establishing accepted facts, allowing the court to focus on the remaining contentious issues.
Understanding judicial admissions is essential in legal practice, whether you're a lawyer, a litigant, or simply an informed citizen. Judicial admissions are a cornerstone of legal practice, affecting every aspect of litigation from strategy to outcome. For lawyers, they offer a means to streamline cases and focus on pivotal issues. For litigants, they represent both a risk and an opportunity, necessitating careful management and strategic communication. For citizens, they provide a window into the workings of the legal system, promoting a deeper understanding of justice and legal processes. By gaining a thorough understanding of judicial admissions, individuals from all walks of life can better navigate the legal landscape, make informed decisions, and contribute to the pursuit of justice within their communities. Whether you're a seasoned legal professional, a party to a lawsuit, or simply an engaged citizen, the importance of judicial admissions cannot be overstated. They are indeed essential to the practice and the integrity of the law.
In every court case, the truth is key, and judicial admission ensures that the truth is acknowledged and upheld. The interplay between the truth and judicial admissions is pivotal in ensuring that justice is served. Judicial admissions reinforce this foundation by ensuring that acknowledged facts are respected and upheld. Together, they ensure that the legal process remains focused on delivering fair and just outcomes, thereby maintaining the integrity and trust in the legal
system.